In this video, let us see about Indian Express March 16, 2022 newspaper. Let us move into the first article. It talks about Karnataka High Court uphold hijab ban in class, not essential to Islam. That is stating that wearing the hijab is not an essential religious practice in Islam, and freedom of religion under Article 25 of the Constitution is subject to reasonable restriction. Okay. Next article that we are moving into is the same article. Uniform are prescribed and rules that prescription of school uniform is a reasonable restriction that is constitutionally permissible. We are considered opinion that prescription of a school uniform is a reasonable restriction, constitutionally permissible, which the student cannot object to. We are considered that opinion that government has power to issue the impunged government order dated February 5, 2022 and no case is made out of its validation. Whether wearing the hijab is part of essential religious practice in Islam faith under Article 25 of the Constitution. Holistic view. The key decisions are presented as answer to 4 questions are formulated by full bench after it took a holistic view of entire matter. Whether the prescription of school uniform is a violation of fundamental right guaranteed under Article 19 Class 1 A, that is freedom of expression, and Article 21, that is right to privacy. Whether the government order dated February 5, 2022 was impetent, arbitrary and violation of Article 14-15 of the Constitution, which guarantee right to equality and protection against discrimination. Whether disciplinary action should be initiated against the official of the government colleges for barring girls from attending classes with hijab. The full bench rejected the comparison drawn by the petitioner with the center and Kendriya Vidyalaya where hijab is allowed to be worn with the school uniform. We are not impressed by this argument. Reasons are not fair to seek. Firstly, such a proposal, if accepted, the school uniform ceases to be uniform. There shall be 2 categories of girls: those who wear uniform with hijab and those who do it without. That would establish a sense of social separateness which is not desirable. Next article is related to narrowing of freedom. Before seeing this, what the court argued: summary of order, hijab is not an essential practice in Islam. Prescribing uniform is institution's right, and the state order not discriminatory. Although it could have been better drafted, no case against college authorities. Karnataka over the essential religious practice test. Supreme Court has devised a practical test of shorts to determine especially which religious practice should enjoy constitutional protection. This has come to be referred as essential religious practice test or essentiality doctrine. 7-judge bench of Supreme Court laid down the doctrine in the Shirur Mut case, saying the term religion will cover all rituals and practices that are integral to the religion. The court said, which constitutes the essential part of the religion is primarily to be ascertained with the reference to the doctrine of that religion itself. Determining the essentiality, they have relied at times on religious texts and other times on behavior of the adherent of the religion or on practices that are originally followed. Legal scholars have also criticized the essentiality doctrine for pushing the judiciary into theological space. The first Anandamargi case, Tandava dance in streets are not essential in the Anandamargi faith because while the faith was born in 1955, the practice was adopted only in 1966. In Muhammad Zubair Corporal versus Union of India, the court distinguished this case from that Sikhs who are allowed to keep a beard. Supreme Court upheld the discharge of Muslim airmen from IAF for keeping a beard. The Armed Air Force Religion 1964 prohibits the growth of hair by personnel other than those whose religion prohibits the cutting of a hair or shaving of a face. The court essentially held that keeping a beard was not an essential part of Islamic practice, while upholding the accusation of certain areas at Ayodhya Act 1993 by which the center has acquired 67 acres of land in and around spot of Babri Masjid had stood a five-judge constitutional bench had ruled that mosque is not an essential part of the practice of religion of Islam, or namaz prayer by Muslim can be offered anywhere, even in the open. Okay. Next article that we're going to see is narrowing of freedom. Hijab judgment privileges discipline and control over liberty and diversity. Religion has been at the center of human societal existence since time immemorial. Religion has always been indispensable and inevitable part of our life. The doctrine of essentiality and how hijab is not an essential religious practice of Islam, and therefore concluding the petitioner argument against hijab are liable to rejection. Sabarimala Review 2020 clearly shows that Supreme Court itself is in doubt about the correctness of essentiality doctrine and whether the court should assume the role of clergy, important to discipline and control over liberty and diversity. Religious freedom is premised on belief that every human has inherent dignity to explore his or her conscience, pursue the truth. Religious practice promotes the well-being of individual, family, and the community, and the denial of unnecessary leads to frustration. The history of hijab is quite complex and has been influenced by the intersection of religion and culture. While some women no doubt while themselves because of the societal pressure, and others do so by choice. The court has rightly concluded that freedom of religion under Article 25 has been subordinate and made subservient to all fundamental rights. Supreme Court in Sirurmut held that the term religion in Article 25 covers all rituals and practices that are integral to the religion. In this manner, the judiciary took it upon itself to determine which is an integral part, which is not to religion. United States, whereby plaintiff could just assert the particular practice was religious practice. Karnataka High Court has now said that hijab is not an integral to Islam. This author has been writing the essential religious practice doctrine is erroneous and gives court extremely wide power in purely theological matters. Anand Margi case, the apex court denied protection to Tandav dance because of the Anand Margi faith came in 1955, but the dance was introduced only in 1966. The religions do evolve over time. To say whatever is not in Vedas or Shrutis is not essential Hindu practice may greatly undermine the freedom of religion of Hindus. The Young Lawyer Association judgment 2018 that insists on the foundation of practice that has been relied upon Karnataka High Court that the foundation of the practice must precede the religion itself or should be co-founded with at the origin of the religion itself deeply problematic. Gandhi versus Union State of Bombay 1954 Supreme Court has said that no outside the authority has right to say that these are essential part of religion and it is open to secular authority of the state to restrict or prohibit them in any manner they like. If we go by Karnataka High Court judgment, the hijab is not essential Islamic practice because there is no punishment for not having hijab. It may lead to conclusion that adultery and homosexuality are considered to be haram, that is prohibited, as they are severe punishment for them under Islam. The conclusion of the court is that it is not that if alleged practice of wearing hijab is not adhered to, those not wearing hijab become sinners. Islam loses its glory and it ceases to be religion. No religion would lose glory because of the state disallowing a particular practice. The assertion of individual right to general detriment of general practice and decorum, the court went on to conclude that even the substantive rights